Thank you. Member for Thornley.
Thank you, Acting Speaker. Acting Speaker, I rise to make a contribution to debate on the Evidence Bill 2025. This bill is proof positive that as members of this place, we are here for a reason, to pass laws that make a real difference to real people who need Parliament to refresh the statute books to reflect society's values and to help deliver justice. It's a great honour and privilege to speak on this bill, to have a voice in this chamber that I can use to speak for those who deserved better from the justice system in the past and whose stories demonstrate the value of this new legislation for the future. I'd like to begin with a thank you to victims, survivors, witnesses all over Western Australia who go to court to testify. You play an essential role in the justice process. Your bravery and commitment to public duty is often the difference between an offender being held to account or not. As a journalist, I spent a lot of time in hearing rooms, criminal trials, civil cases, royal commissions, inquiries of the CCC and other inquiries, all of which rely on witnesses to expose themselves to the stress and discomfort, often, of being publicly questioned, having given an oath to tell the truth. I've sat in court as people have relived some of their most traumatic moments of their lives in front of strangers, not knowing what questions might be asked and what consequences might flow if they don't get it right. They deserve our gratitude for their public service, and I'm pleased to speak on a bill that codifies measures to improve the experiences and support for witnesses. No legislation will make this system perfect, but these measures will help. This bill is wide-ranging and, as the Attorney-General said in his second reading speech, it contains some reforms that will greatly assist prosecutions in the cases of family and domestic violence. A particular note is the new provision for using police officers' body-worn camera video for prosecutions. This is a potential game changer in this space, and I'm sure the House will hear more details on that, and we already heard some. Over my career, I've taken interest in many cases involving sexual abuse, and I was in the media room for the Perth hearings of the Royal Commission into Institutional Responses to Child Sex Abuse in 2014. I remember the first emotional day of hearings in Perth, elderly men in their 70s testifying about the horrific abuse by Christian Brothers in places of misery like Bindoon, Clontarf, Castledare children's homes. They were elderly, but as they recounted the cruelty and depravity from long before, it's like we could hear the voices of the frightened little boys whose nightmares they were reliving. Journos get cynical and hardened, but several of us were weeping as we typed our copy for the next day's news. These men mostly kept their sexual abuse secret for decades. They didn't tell their wives and children, let alone police officer or a judge and a jury. That Royal Commission has resulted in a better understanding of child sexual abuse, and which is reflected in the reforms contained in this important bill. The abolition of what is known as the Longman Direction or the Longman Warning, the protection of witnesses from belittling cross-examination by lawyers for the accused, and a suite of other reforms that have been outlined to help vulnerable witnesses give their evidence. Child sexual abuse is insidious, and it can only be tackled if perpetrators are convicted and dealt with. But the adversarial system that we have and the hidden nature of abuse, meaning that there's often no corroborating evidence such as CCTV or independent witnesses, mean that it's often a matter of he said, she said, or he said. So the defence tactic becomes one of ruining a complainant's credibility. Some victims emerge feeling that they themselves have suffered cruel punishment in the justice system. During this contribution, I will give voice to the experiences of two women who I've come to know, respect and admire. These women who don't know each other, but who can attest to similar experiences, are honest, they're brave, and they're of the utmost integrity. Both cases involve the insidious behaviour of men in authority grooming minors. for their own sexual gratification, leaving them confused and psychologically scarred. One of the women describes being 14 when a middle-aged man in authority started grooming her, and 16 when he stole her virginity. She was not protected by the man's employers, and decades later, she went through the court process, which resulted in an acquittal. The other woman is the mother of a brave young man who was abused in primary school by a popular teacher. He made a complaint to police 10 years later, only to find that there were many other victims, and at that school had been warned about the man, but protected their reputation instead of protecting children. This prosecution resulted in the teacher being found guilty twice. There was relief after a gruelling district court trial that the offender was convicted of abusing 5 boys and he was sent to jail, but the offender appealed and they had to go through it all over again. The cross-examinations by the Defence Counsel, which I watched while I covered the retrial, were brutal. Again, the former teacher was convicted, and in the process, the witnesses were again re-traumatised. Through the dogged determination of this mother to hold the school account and the system to account, this case too became a featured case in the Royal Commission's hearings in Perth. Both of these women can talk of the impact of the Longman warning on their cases, and both can speak of the trauma of the process, particularly the manner in which Defence Counsel can re-traumatise and psychologically damage witnesses. With their permission, I will read some of their words later in this speech. Acting Speaker, as you've heard, West Australia is an outlier in keeping the practice of the Longman warning, which is often given to juries in sexual offence trials, and as you know, it comes from the case of Longman versus the Queen, which is back in 1989, more than 30 years ago. The rule requires a judge to instruct the jury that if the victim had delayed in making a complaint and the accused may have suffered a forensic disadvantage as a result, that it would be dangerous to convict the accused solely on the basis of the complainant's evidence, and that the jury must scrutinise the complainant's evidence with great care. Can you imagine being a victim of abuse, finally getting up the courage to go forward with a complaint, mustering the bravery to take the witness box and be cross-examined, only to hear at the end of it, the judge tells the jury that it would be dangerous for the jury to believe you and to convict your offender? Through the work of the Royal Commission and many other sources, it's now known, and it's an accepted fact, that many sexual offence victims do not make a complaint immediately, and some victims don't make an official complaint at all, like those men in their 70s that we heard from in the Royal Commission who had never even told their wives. We now understand the process of grooming, the shame, the blame, the stigma, the fear and anxiety, the effects sometimes of substance abuse, of PTSD, the lack of support, the lack of belief in the justice system to meet their needs. Overwhelmingly, the victim survivors I have encountered decided to go through with the process for reasons that are selfless and for the public good. The first reason, and usually the most important reason, is to stop the offender from doing it to someone else. Or it's to support other victims by corroborating their statements, or it's to hold the perpetrator to account and place on record what they've done. With this bill, judges will not be permitted to give the Longman warning and potentially prejudice the complainant's evidence when we know that such a delay is a normal feature of these kinds of matters. But importantly, the bill does reflect the need for accused people to be able to properly defend themselves, and that is important. And it acknowledges that in some cases, depending on the facts of the individual case, juries may need to be warned about disadvantages to the accused. Defence counsels will still be able to request the judge to give warnings about disadvantage, but they can no longer tell the jury that the fact that the complainant delayed in making the complaint affects their credibility. Some victims don't make complaints because they fear the process itself and the way that being a witness can further traumatise them. This is something that this bill is moving to address. Clause 50 of the bill expands the definition of improper questioning of witnesses. Acting Speaker, as I said, lawyers must be able to represent their clients and to test the evidence before the court and to ensure that only the guilty are convicted. Defence lawyers do a very good job and an important job, and I'm not criticising them as a whole. Most of them do it professionally, but unfortunately I have been in court and watched the belittling of witnesses by Defence Counsel in sexual abuse cases, such that it's made my blood boil. And I'm very happy to see this being legislated. The current Evidence Act defines improper questions as those that are misleading or unduly annoying, harassing, intimidating, offensive, oppressive or repetitive. This bill expands improper questions to include those asked in a belittling, insulting or inappropriate manner or tone, such as I've witnessed, and those who have no basis other than stereotype. And these rules will be extended to witnesses in civil proceedings and will restrict the humiliating practice of witnesses being cross-examined about their sexual histories. And I advise these restrictions have been in force in criminal trials since the 1980s, and it's good to see that they've been extended to civil matters in this bill. Very importantly, Acting Speaker, the bill will also create an explicit positive duty for the court to intervene to disallow all improper questions. So there'll be a requirement for stricter compliance. I do hope that the judges and magistrates heed this message by the Parliament that witnesses should not be subjected to such traumatising cross-examination. This reform is one of the many improvements in the way that witnesses will be treated and supported in future criminal cases and civil matters, measures which have been discussed and which will be further discussed during the detailed examination of this bill. And they include the introduction of witness intermediaries, which was another recommendation of the Royal Commission. They are independent court-appointed experts such as psychologists, speech therapists and occupational therapists, and they assist the court to understand and accommodate the witnesses' communications needs so that their evidence is as complete, accurate and coherent as possible, and hopefully less traumatic. Earlier in this speech, I told you about a woman who had been a 14-year-old when a middle-aged man was employed in a position of trust, and he began preying on her. This lasted several years and deeply affected her. It took decades before she made a complaint to the police, which came about because she wanted to support other women who had also been abused at this institution. A successful professional who is respected by her peers for her work in service to the public, she was left feeling a sense of injustice and betrayal when her trial resulted in an acquittal. Like many complainants, her evidence was subject to the Longman warning to the jury, who heard that direction not just during the judge's general summary, but again at a crucial time during the deliberations of the jury. The jury came back with a question which was something like, if they believe the witness, can they convict? The judge, in answering the question, reminded the jury of the Longman direction, and soon after, the jury then came back with a verdict of not guilty. It felt like a kick in the guts to someone who prides herself on honesty and integrity and had endured a public cross-examination in which she was accused of making up allegations to make money from compensation. It felt even more unfair because the Longman warning is based on the forensic disadvantage to the accused because of time lapse between the events and the trial, but that delay also causes forensic disadvantage sometimes to the complainant. These are the words that she has given me to say. Had I been supported and been in a culture to come forward at the time, I would have had access to evidence that the prosecution could have used at trial, like receipts and phone records and freshness of memories. The forensic disadvantage is not limited to the defence, it's a real disadvantage to victims too. The reasons for not coming forward included shame and blame. The nature of grooming, particularly by someone in authority, is an abuse of trust. For a very long time, I thought that I had done something bad and would be in trouble because I went along with it. It wasn't until I was over the age of 30 that I stopped blaming myself and seeing myself as the person who'd done the terrible thing, a really bad person. By then, I was a professional. I didn't want people to know what had happened to me. But eventually, I did come forward to support my friend who had also been abused. It felt like I was finally going forward with support from the police and the prosecution. The process was unblocking that shame and having the feeling that I didn't do anything wrong and I shouldn't be ashamed. But then, when the Longman direction was given and he was acquitted, it's like I went backwards. Everything had been opened up to heal and then the process stopped. What I did support other women to hold the institution to account, so I'm glad I did it for them. But if I'd have known what happened, I wouldn't do it again. While the Longman direction is being used, I'd say that unless you complain quickly, it's not worth going through a trial. After the acquittal, I was overwhelmed with a feeling of unfairness and injustice. The second woman I mentioned earlier in this speech made a submission to the Royal Commission, which, as I mentioned, her case became one of the major cases at the hearings of the Royal Commission here in Perth in 2014, and she has given me part of that submission to read to you today, just to describe the experience of her and her son. My son was sexually assaulted by a male teacher when he was 9 or 10 years of age at a school. He disclosed to me when he was 19. That same day, my son and I reported by phone to the police and attended the police station to support my son to make his police statement. My son and I were separated. Both of us were interviewed by separate police officers, and this was tape recorded. We had to travel all the way into the city to attend a specialised sex abuse police unit. I found reporting and being interviewed extremely stressful, trying to tell everything that I knew that I thought might be relevant, recall names of people, dates and events. Much of that information I gave, I'd never disclosed to my son. I felt a lot of pressure to get details and names right in case I got people into trouble or other people who didn't deserve it into trouble. I was frightened about what my son was going through in the other room, worried about my other son who was still at the school. May I please have some more time?
Yes, of course.
Thank you. I was very scared, angry and in shock. Approaching the police was extremely stressful and frightening. We felt overwhelmed. The officers at the Child Sexual Assault Unit were supportive and they believed us. However, they told us the chances of getting convictions were extremely low in child sexual assault cases. During the investigation, further victims in relation to the same offender were identified and then made complaints. One of the most difficult aspects of the process for complaints and their families is that although the accused is legally represented, the complainants themselves are not. And I know that this is a very common experience and that a lot of victims have, that there's no one in the courtroom who is their lawyer the way that they would in a civil matter. And the DPP, while I think they do their very best to protect the victims, they're really there on behalf of the state in order to try the person. And she said this leaves victims and their families feeling very disempowered and unprotected. She said, "We found the conduct of the defence team to be very intimidating, menacing and distracting, including the way that they looked at the complainants and their families, the questions asked of the witnesses and the manner of their conduct. The manner in which children were ruthlessly and aggressively intimidated, and this was allowed by the court, was disgusting. In relation to my son, for example, the Defence Counsel again and again called him a liar. This occurred in the first trial and almost resulted in the parents of one of their 2 primary school-aged sons, both complainants, not allowing their second child to give evidence and face cross-examination. Remember, this is a case in which the offender was found guilty, not once, but twice, so there's no question. And further, the jury were told that we were simply pressing charges for the money and that, quote, there was a pot of gold waiting for us, unquote, at the end of the retrial. This was insulting, and whether we later pursued our rights to civil settlement from the school is irrelevant to the criminal conduct of the accused. The trial was conducted in open court, and this meant that members of the public, strangers, attended the public gallery to watch proceedings. And anyone who sat through a sexual assault trial will know that the kinds of questions even asked by the DPP can be deeply embarrassing. They are asked to use the correct anatomy. They are asked to give very explicit descriptions of the things that happen to them, and these are almost always held in an open court where people can walk in and out. And as this mother said, she was very grateful that the witness people made sure that a school group that was going through were asked to not go into that courtroom. The result of the first trial was successfully appealed and there was a retrial. The basis for the appeal was the original judicial officer's misstatement of the Longman direction. In order for the retrial to proceed, all three complainants whose charges it related to, I think he successfully appealed on three, but not on the other two, had to agree to give evidence for a second time. One of the complainant's evidence had luckily been pre-recorded via CCTV during the original trial, and this meant that he didn't have to take the stand again. This is another good measure in this bill, and I think keeps some of the good provisions that we already have in Western Australia. But this meant it was left to my son and the other complainant to participate in the retrial. She says her overall impression is, and this is what she said in her submission to the Royal Commission, sadly, child sexual abuse trials seem largely dependent on the ability of lawyers for the defendant to destroy the credibility of the victims of the abuse and the ability of already abused, traumatised and vulnerable victims to withstand this re-abuse. Our trial and what we were put through in the legal process was so traumatising that a number of our close friends who witnessed it have told us they would never now report to police if their child disclosed to them had they been raped or sexually abused. This should shock the legal fraternity into taking action to rebalance the system. And Acting Speaker, I'm very pleased to be standing here to be speaking on a bill that goes some way to doing that. I'll just also read something that is more positive, where she told the Royal Commission about the witness support services that already do exist, and while we're talking about new supports for witnesses, there are still some that do exist, and they did at the time. She describes them as excellent and an important service. They made themselves available from early on. They organised counselling for her son, provided him with information, helped him with his victim impact statement. And also the victim notification register were very supportive and very helpful. So, Acting Speaker, I think we, after hearing a fairly bleak description of their experience, we still can be thankful that there are really good people in the system already who will be joined by more people in the system to support victims and witnesses in these cases. And I thank the author of those words, a woman who I know is watching at the moment, who worked with the Royal Commission and others to use her son's experiences and her own to help make changes in the system for the better. Yeah. If I have time, I thank you, Attorney General, for bringing this to the 42nd Parliament. Also acknowledge the former Attorney General, John Quigley, who worked for many years on this bill to make it a reality. And I know he was particularly keen for this legislation. I know it took time, but it was nuanced and it's complex, and it was well worth the time. Also, the former Director of Public Prosecutions, Amanda Forrester, SC, who's now the Supreme Court Judge, put an awful lot of work into this when she was at DPP. And of course there's a wonderfully talented staff at the Department of Justice in their legislation team who are incredible and have worked assiduously, as well as the drafters at the PCO and the officers who worked in the former Attorney General's office and the current one now, and I thank them for their assistance with this speech. It's also essential that these reforms are reviewed by those who represent the accused people to ensure that the system of presumption of innocence and guilt proven beyond reasonable doubt are upheld. It's still important. And the 50-odd stakeholders who were consulted included Legal Aid, Aboriginal Legal Service and Criminal Lawyers Association, who do that important work. I'd also like to acknowledge the Child Sexual Abuse Squad of the West Australian Police. Their work was highlighted just a couple of weeks ago by Ben Harvey in his column in the Sunday Times, and he wrote about the squad's development of a new technology to assist with their inquiries, Safe to Say, which allows a victim to survivor to report when they're ready and negates the need for them to go to a police station or call police, which can be daunting for some. It gives them the ability to follow up questions and gives them a chance to understand what occurs during an investigation, what their rights are and what to expect if an investigation is commenced. It's great to see that not only are we improving our statute books, but the police are using ways also to make it easier for people to come forward and hopefully receive better outcomes in their investigation. Ben is actually on the board of Crime Stoppers, and it's great to see him using his column space to promote the public interest. He quoted statistics that the Sexual Assault Squad had received more than 2,000 complaints about sex crimes in the past few months and arrested 40 people, charging with 170 offences. That gives just a hint of the size and scope of this challenge and the imperative to enact the best laws possible to address it. Before I conclude today, it is fitting today that I acknowledge members of the Stolen Generations and their families, many whom have been impacted and continue to be impacted by the institutional sexual abuse by clergy and others in authority when they were taken from their families and placed in institutions, just as we talked about those elderly men who I watched testify at the Royal Commission. The damage caused by this insidious abuse cannot be underestimated. Speaker, I began this contribution with a thank you to all of the witnesses who have served the public by testifying in court under difficult circumstances, and I repeat that. And I hope that after the passage of this bill, more victim survivors will be willing to go through the process and that it brings you a better quality of justice than those that came before. I also send a message to those victim survivors who do not feel ready or able to come forward at this point, that we understand the complex reasons for that and we support you. And a tribute to those who had never reported, who have been lost to the world, whether through post-traumatic substance addiction or trauma-related causes resulting from child sex abuse. May you rest in peace. I commend the bill to the House.